Hey everyone, I remembered to hit record this time. It's Eric, it's Abigail Morrow. Why don't we get right into, well, before we get into what we're going to talk about today, we're going to talk about a lot of staffing topics because I am joined by a total expert on this. I'm going to do a quick disclaimer. Folks, I'm a lawyer, Abigail's a lawyer, but we're not your lawyer. No one tunes in to a free 1-hour Zoom for legal advice. That's just crazy talk, okay? That's nuts. If you have real legal questions with real specific facts and things like that, talk to your lawyer. Ask us hypothetical questions. Just make them up. Ask them for a friend. We'll give hypothetical answers. We're never giving legal advice. We're never creating attorney-client privilege, but we do say it depends a lot. And I know that can be confusing for you because your lawyers do that too, but remember, we're not your lawyers, okay? All right, with that out of the way, Abigail, we got a lot of topics we want to talk about today. Let's talk a little bit about something I don't think we've ever discussed here on one of these Zoom chats before and rarely gets much play on the Employer Handbook. Let's talk about immigration. Let's talk about I-9s. So we've got a situation, we've got staffing company, and we've got customer or employer, I'll refer to them that way, client, and there's an audit coming up, and that involves I-9s. What should employers be thinking about in terms of an I-9 audit?
Sure. So we get this question a lot, which is somewhat confusing because it's been pretty well established since 2010 when the DOJ issued a letter on the topic. The I-9 documents are only to be used by 3 very specific entities, none of which are your client. So your client's going to get real panicky and they're going to want to see your I-9s. What the Department of Homeland Security says should happen is that you, as the employer of the talent, we're going to use that word, associate, temporary worker, whatever you want to use, it is your job to hold those I-9s, but you are legally barred from sharing them with the client where they are placed. An acceptable outcome for a DHS audit in that situation is an attestation from you as the employer to the client saying, we have that information, and if DHS needs it, we're more than happy to provide it to them directly. But you under no circumstances can either produce the I-9 verification form, you cannot show them the documents, but they didn't take a copy of it because somehow that makes it better. All of those things that clients try to get you to do, you're not allowed to do. And it's really clear in federal law, and it's really fascinating to me that this far removed, I'm still fielding that question, hypothetically, on a regular basis and having to explain to in-house counsel for larger companies that that's not going to fly. Can't do it.
Oh, folks, if you have questions, because everyone's muted right now and everyone's probably going to stay muted, hopefully if I did this right. If you have questions, throw them up in the chat. There's a little chat box for those of you who are using Zoom for the first time. A little chat right down at the bottom middle of your screen. And we have a question already from Stephanie. She asks, should companies have that attestation in advance or wait until they get audited? What do you think?
Generally, I would recommend just waiting until there's an audit that needs it. Otherwise, it's just another layer of paperwork for your field, and it just creates more drag on the system. So it usually happens in a very specific fact pattern, and it happens when those clients demand it. Although I will say be aware of your contracts as well, because a lot of times clients will write that into the contracts that they are contractually entitled to see your I-9 documents. And you can contract for anything you want to except for illegal stuff. And it's illegal, so it doesn't matter even if it's in the contract. I've had that conversation more than once.
Your level of snark is perfect for you're invited to guest blog anytime you want. Let's move away from I-9 and let's talk a little bit more about everyone's second or third favorite topic, because we know everyone's favorite topic is FMLA intermittent leave, but second or third favorite topic is wage and hour. So first, let's talk about, rounding time, kind of a wonky wage and hour topic, but something that probably would come up a fair amount in a staffing situation. So I'll just say generally for employees, for folks here that aren't aware, you can do rounding of time. You have to do an even increment on both ends, 6 minutes, 15 minutes, something like that. But you have to round evenly. So if it's half the time you would round in the employee's favor and half the time you would round in the employer's favor, depending on how far past the hour or how far, whatever increment you're using. Is there anything beyond that in the staffing context that people should be for with rounding time?
Yes. So again, it's one of those things that sometimes happens inadvertently. Obviously, from a staffer perspective, it's to your advantage if you're the staffing company to make sure that you're getting exact time, because it's, as the employer, it's going to fall to the staffing company to ensure that they are compliant with FLSA. So sometimes, hypothetically, you might see a client who's trying to game the system a little bit and have you put up quarter-hour rounding so that you're rounding on your clocks 7-minute increments. But then also making rules that nobody can clock in until 6 minutes before the start of the shift. So you end up with some situations where if you're stacking the deck in the favor of the employer, and if you go back and do an audit of that time and if it's not working itself out, then you probably have a problem. The other thing to be aware of in those situations is, so I'm allowed to clock in earlier, but once I clock in, they make everybody go stand in the break room for 10 minutes until we all walk together to our line. A lot of clients will get very upset about whether or not they need to be charged for that 10 minutes they're in the break room. I will say that those are very fact-specific situations, because should a manager pass through the break room getting his coffee in the morning and say to the group, oh yeah, by the way, let's make sure we have all of our PPE on. Did you just have a safety meeting? Is that time now compensable? And from a staffing perspective, you don't have any control over any of that situation. So it's very hard for you to be able to establish whether or not people were working. And that term is debatable under the FLSA, whether or not they were working during that gap where they may not be trying to pay them. You'll also see this with shift time. Some clients will also try to push for shift time, where everybody's time starts, the shift is 8 to 5, that they, no matter what time you get there, that they start that clock at 8 a.m. And again, it's going to be very fact specific about whether or not that's what's actually happening. If somebody so much as picks up a broom before 8 a.m., then you're on the hook. And the reason this is such a terrible, terrible topic is that it's a statute, which means you either win or you lose. There's not a lot of wiggle room. Eric's an amazing attorney, but there's only so much dancing you can do when either you did it right or you didn't. And the costs are, they escalate exponentially and quickly.
Yeah. 5 months ago, I probably could have danced a little bit more. Now, starting in, I don't know, what was it, January 21st, probably less dance. Less dance. I've already seen this, folks, with the Department of Labor. I mean, they are getting more stringent. There is more of a focus on compliance and litigation than kind of hand-holding and helping employers work through these issues. It's not to say it's impossible that they would do that, but there's more of a focus on, employers that engage in wage theft. We've got to make sure that all the employees are getting paid the right amount, versus guiding employers and educating employers with opinion letters, things like that, about how to avoid these situations. We saw the PAID program is gone, which was that voluntary first-time offender program. If you do an audit, you realize you owe money, you could voluntarily disclose and work with the DOL to basically get it so that you would pay just the wages and not have to pay any liquidated damages or anything else. You'd avoid the private lawsuit. Things like that are gone now. So there's much more of an emphasis on making sure that employees get paid and not coddling employers.
And I will also say this as well. A lot of times this can happen inadvertently because there's a disconnect between what IT sets the clocks on versus what the field's actually asking for. And typically, if you don't offer, do you want fries with that, to your client, rounding's not something they're going to request specifically. So if you default your sales team to exact punch only, and you default your clock setups to exact punch only, and then the rounding has to go through some sort of internal review process, you're probably better positioned to have a control over some of that risk and be able to analyze that a little more clearly.
What about, what about salary, or I should say salary? What about deductions from paychecks? We have a temp worker who has a uniform that someone's providing, or a temp worker fails to return equipment, or now we have PPE, right? So we've got to provide face masks or other sorts of gear to protect against coronavirus. Are these items that we can, either as the staffing company or as the client, deduct from an individual's paycheck?
Well, so your favorite answer, Eric, it depends.
Yeah. Oh.
It does depend. So it's very fact specific. PPE, the general answer is no. There can be some times when there's excessive wear and tear. Face masks right now, as far as the latest I've seen, are still not considered PPE within the context of coronavirus. So there's probably a debate there, but then you also always have the public relations side of, do you want to be that person that ends up on the evening news that you were charging hourly workers who were essential, who are going to work, for their masks? Might want to give that some broader thought outside the whether or not you can legally do it versus whether business wise you should do it. So, and then every state also has very specific parameters as to whether or not certain materials are deductible and certain materials aren't. A uniform shirt may be deductible in, say, Washington State, 100%, or excuse me, reverse, not deductible in Washington State, but in Alabama, sure, you can hit them for whatever you want to. Most states have very specific provisions about notice to the employee, that you have to give them written notice. They have to know the specific amount that's going to be deducted, and they have to have that notice within anywhere from 7 days to several weeks before that change is made on their paycheck. So it very much is state specific, and probably in California, I would venture probably even municipality specific as well.
So the moral of the story is, don't be a multi-state employer.
Yes.
Folks, if you have questions for either Abigail, please put them up in the chat. I see one right here. Carrie asks, if we have flexible scheduling, this is going back to the rounding.
Yep.
If we have flexible scheduling, so employees can make their own scheduled start and stop time anytime between our open and close, as long as they schedule 40 hours per week. All right. Do we need to do the rounding, or can we pay them for the exact minute they clock in until they clock out? Oh, I can answer that. If they're not exempt, you can pay them for the exact minute they clock in to the exact minute they clock out. Now, if they, subject to if they take a lunch break, things like that, presumably it's a 30-minute or more lunch break and they're not working, so you wouldn't necessarily pay them for the lunch break, but shorter breaks, 20 minutes or less, generally under the Fair Labor Standards Act, you're paying for things like bathroom breaks, smoke break, things like that. If someone works through lunch, you're going to pay them for that. But rounding isn't a requirement by any means. It's in the Fair Labor Standards Act. It's in the regulations to offer some flexibility for more industrial locations, things like that. But rounding's an option, but not a requirement. If you're going to round, just make sure you know the rules. How about? I'm blissfully thinking about when we warm up. I'm looking at the snow outside. We get towards the summer, school ends, and businesses might start employing minors. Hopefully we get back to some kind of normal workplace where people are coming into the office and we're employing minors. What are some of the issues that staffing companies and their clients should be thinking about when employing minors?
Well, I will say that right now we are actually seeing a surge in minor request hiring because they're all in virtual school. So some enterprising minors have cracked the code that they can both do their schoolwork and get paid during the day simultaneously, because they don't necessarily have to log on. They just have to accomplish the work. So it's a little bit more like a college situation for those older high school students than they have had that opportunity to do before. So the first question, and it seems like an obvious one, but it turns out that it depends on who is a minor. It's not necessarily just because you're under the age 18, it's defined specifically by each state as to whether those people have additional considerations that need to be made for them. The state of majority the age of majority varies by state, and every state's DOL has a different standard for who gets special regulation and who doesn't. So just because I'm 17 in Georgia doesn't mean that I'm subject to state mandates. In fact, I'm not. Plus, if I'm 17 and if I'm 17 and I've dropped out of high school, then I would still be considered a minor. If I'm 17 and I've graduated high school, then I'm no longer a minor. So you really have to get down into the nitty-gritty with your applicants to decide whether or not they're falling under those certain provisions. And then you also really have to have a clear understanding of what the state requires you to do. A lot of times there's limitations on what hours they can work, how much they can work, whether they can work until 10 p.m. on the night before a school day. None of those rules have changed, even in virtual time. So despite the fact that they may not have to be physically present at school at 7 a.m., you may still have to watch their scheduling as to whether or not they can come. Also, there's just the business analysis of whether you want to take that risk of a 17-year-old or younger on your property, depending on what the line of work that you're doing entails.
Yeah, in the hospitality industry, obviously that's big, restaurants, things like that. You might have someone working up front as a host or hostess, or even as a server potentially. From my personal experience, when you see wage and hour audits, a lot of focus on employment of minors. That is very low hanging fruit. I mean, you might have an otherwise clean bill of health, but you may get dinged on something to do with employment of minors. So just be very careful of that. I'm not saying the feds would ignore it, but from a state wage and hour standpoint, it seems to be a big issue when I've encountered audits and dealt with audits.
And then also just an added consideration on that, which is more privacy than employment, but they go hand in hand, is that if you're asking a 16-year-old or a 17-year-old to release their social security number to be able to do a background check on them, I would highly recommend that you have a parental authorization on that as well, so that everybody knows what's going on as to whether or not the parents are fine with that, so that you don't get tagged on running their credit before they're ready to have that information released.
Changing gears a little bit, from the staffing company standpoint, we've been talking a little bit about clients that get a little bit out of control, that are doing a lot of maverick stuff. How do you, as the staffing company, tell the client no without losing business?
You know, it's the hardest skill, and it's one of the ones that we talk a lot about when I do trainings with my clients, in that many clients approach a staffing company as a workaround. Well, I would prefer that all of my employees be Spanish speaking. And you can do that, right? Is there a job necessity for them to be Spanish speaking, or are we just dealing with something else right now? Right, so your field's going to field a lot of questions that would fall in that, I'm sorry, what are you asking me? Category. And really what I find most useful is to give your salespeople the tools to address those concerns in a way that is not confrontational. So I am based in Birmingham, Alabama, so the bastion of good Southern passive aggressiveness. There's a couple ways to do that. One of the ones that I find most compelling for our clients is if you push back and say, you know what, we really want to make sure that we are comporting with your operational standards. So if you can show me the written policy that you have on that, I'll make sure that I train all of my people correctly. Which what that does is that it forces the contact that your salesperson is working with to go back through his or her chain of command and find that policy, which 9 times out of 10 turns out that policy was updated in accordance with the law 15 years prior. but they never they never updated their expectations or standards. So it's an easy way to kind of shift that conversation to an internal conversation so that people can find out that that's not how, no, why would we have that policy? No, we don't have that policy. And here's why we don't have that policy. So it kind of pushes the onus back on the client to establish their rationale for that. I also tell my field all the time that if you go on a sales call, it's a lot like dating, right? Everybody's putting their best face forward for that interaction. And if that person looks at you dead in the eye on your first meeting and says, hey, will you violate federal law for me? It's not going to get better if you get that business. So you want to be very clear on, no, we're not. And here's what we do and here's how we handle those situations.
What if we flip it around? What are some of the things that the client should be looking for when vetting a staffing company? Just thinking in terms of pure HR compliance. What are some of the things that should be on the client's brain?
Sure, they're going to want to know that you do follow those laws and that you are going to be compliant with the EEOC, that both parties have a good understanding of where the responsibility lies for OSHA, for certifications. Forklift drivers, powered industrial truck drivers have to be certified on the site by the client for the piece of equipment. And so just making sure that there's clear lines of communication and that you understand your obligations is the first line of defense. That if that staffing company is telling you things like, yeah, we can do that, we can get you whoever you want, just let us know, wink, wink, nudge, nudge. Again, if you're willing to outwardly violate laws on that standard, then you're probably going to get in trouble down the line for whatever else happens. Same thing on the reverse is that if my client's asking me to do that, then I'm also going to venture that my people who I put there are not going to be probably following OSHA guidelines, right? If you're willing to break one rule, you're probably willing to break a lot of others. And so on both sides, it's that communication and that trust, and tell us what your policies are, tell us what your procedures are. How do you vet our employees? What is your background check procedure? What is your drug testing procedure? All of those things a reputable staffing company should have at the ready and be able to give you multiple resources of what those policies and procedures are without any hesitation.
How about investigating a complaint of harassment? So a temporary worker complains that a supervisor is harassing him or her. Where's the responsibility fall at that point?
It gets really tricky in staffing, right? Because my employee is the one who's making the complaint. Your employee is the alleged aggressor. I don't have control over your employee. So it's a tricky situation. That should be something that's addressed in the contract and the initial relationship, that we understand everyone's going to be cooperative in that investigation. From the staffing perspective, you want to make sure that your field is prepared to offer our person another position that is comparable or better at another location if need be, because you do not have the ability to remove the aggressor from their world, right? In a standard employment situation, you could separate the two of them, but you don't have control over half the situation. So you really do have to work hand in hand with their HR and make sure that everybody's on the same page. And again, make sure that people understand from the get-go in those contracts where that liability lies, is that we are a staffing company and what's ours is ours. But you as the client also have obligations to provide for my people, my employees, a safe and friendly working environment.
Because the reality is, if things go sideways in that situation, and let's say the harassment continues or the temp isn't moved, there aren't those prophylactic measures taken, and it gets to a lawyer, gets to EEOC charged lawsuit situation, everyone's getting sued.
Yes, everybody's in the pool.
Right. So segue into two terms we hear a lot in the staffing context: joint employment and co-employment. Could you walk us through that a little bit?
A little bit. So here's the thing, and this is one of my ongoing efforts as a in-house lawyer for a staffing company. Given the nature of a staffing relationship, if it is truly a staffing relationship where you are taking the employees that I supply to you and directing their daily activities and telling them, I need you to build this spreadsheet, to load this pallet, to inspect these parts, whatever you're telling them to do, you are probably going to be a joint employer. And that is because while I am taking on all other responsibilities as far as hiring, as far as firing, as far as discipline, as far as the rest of it, I'm not there on a daily basis. And no matter how many times the client would like to write into the contract that I'm the sole employer, I'm not. And that's going to be a fact-specific evaluation when it gets to litigation standard. One of the other things that I see a lot that I always find very interesting is that the client contract will say, staffing company will indemnify for anything that comes up under a joint employer relationship. Well, that goes right back to the EEOC charges. So the reason everybody gets invited to the EEOC is because it's on the premise that we're a joint employer relationship. And again, it's not my obligation to defend your employee's bad act. There's some relationship that everybody has to take responsibility for those issues.
A lot. It's a lot to deal with. Folks, if you have more questions about joint employer or excuse me, anything to do with staffing that we've discussed today, please put them in the chat window. I'm going to shift gears a little bit and talk about a beefy topic that we're never going to be able to cover in 18 minutes because I want to leave about 10 minutes for answer questions. But I wanted to talk a little bit about mental health in the workplace because I see this as one of the biggest issues, if not the biggest issue of 2021, as hopefully people get vaccinated and we start to bring people back to the workplace. People are going to be scared to come back. So what are some of the things that we can do as employers to kind of get ahead of these issues? And I talked a little bit in a blog post today. If you haven't read it, I talked a little bit about this was pre-pandemic, a case involving an employee who had anxiety at work, needed some time off. There were issues with getting a medical certification. The employer thought the employee had actually faked the doctor's note. I'm not going to get into that right now. But it highlights some of the statutes that employers should be thinking about. And if this is a little HR 101, I apologize. We can get into some beefier questions if you have them. But I just want to make sure people are thinking about the Family Medical Leave Act. If someone has anxiety, depression, really any sort of mental health issue, they don't have to use the letters FMLA to ask for the leave, right? If they're coming to you and saying that they're concerned about coming back to the workplace, it's stressing them out. If they've been with the company for a year, right? If they've got the 1,250 hours, if you know they're eligible, offer them the FMLA, okay? Offer them the leave. They can get certified, bring the paperwork back. If they need leave, you give them the leave, okay? Probably not something that's going to be done on an intermittent basis if someone is stressed out about coming back to the workplace, but you can give them the leave. The other thing that we need to consider is the Americans with Disabilities Act, okay? And ADA claims, I saw a statistic the other day, I think we're up 30% this year. Why? Because COVID. Because we've got to be thinking about how can we accommodate employees who have mental health issues, specifically about coming back to the workplace. Is it possible to keep them teleworking if they're teleworking now? Is it a job that's conducive to teleworking? I know we've discussed this on a prior Zoom chat, but a year or so ago, we may not have considered certain jobs to be conducive to teleworking. We've learned a lot since then. It doesn't mean that any job where someone's been teleworking over the past 10 months is automatically conducive to teleworking and is an automatic reasonable accommodation, but I think the scale has tilted somewhat to suggest that teleworking is more likely than not, or at least more likely than it was before, a reasonable accommodation. So that's an option. Leave from work, flexible work schedules, providing more PPE. The bottom line is this. Take these requests for accommodations, take someone's, I don't want to say complaint, but when someone says to you that I have anxiety, I am depressed, this is bothering me, take that very seriously and pivot into an interactive dialogue to discuss what you can possibly do for the employee. If you want to get ahead of it right now, you anticipate that in a month or so, you're going to be transitioning more people back to the workplace, put it out there. Say, look, if anyone has any issues with transition coming back to work in a month or so, let us know so that we can discuss it with you. There is no problem with generally asking employees if they're going to need some help. How can we help you? If they need an accommodation, you can do that. The EEOC has said that's just fine. I'm sure it's not much different in the staffing context, right? Pretty much same bits apply.
It is, but it also has some challenges because sometimes the staffing company forgets that our temporary workers are also our workers. So that when your temporary workers are also saying, I'm not comfortable with that, they are still eligible for FMLA. And a lot of times, because of the temporary nature of the relationship, they have been there for more than a year. We have some temporary workers who have been there for many, many years. Sometimes the field forgets that our HR is their HR and that they need to be directed to the appropriate resources within the organization so that those concerns can be addressed. Because the staffing agencies are based on churning and burning, right? I just need to fill that job and you find a person. If you don't want to do it, I can find somebody else to do it. I feel like sometimes we get a little busy and we kind of forget what those obligations are to the employees. So that making sure that your field is aware that those complaints do go up to HR, what that reporting procedure looks like, reminding them what those resources are, making sure that you're pushing those resources to your workforce as well, are very key to staying ahead of those types of situations.
And if you go, temp to perm, you start as a temporary worker for a client and you spend, 2 months, 3 months as a temporary worker, 90 days, whatever. And then you become a permanent worker for the client. Those first 90 days count towards the year, right? So if you're there for another 9 months, all of a sudden you have met the 1 year requirement for FMLA eligibility. As long as you've got the 1,250 hours under your belt, as long as you're at a location that employs 50 employees within 75 miles, and you yourself have a serious health condition, because we're talking about mental health for employees themselves, you're FMLA eligible. These employees are FMLA eligible, and you have to treat them as such. What about a situation in which a client terminates an employee on the grounds that an accommodation imposes an undue burden? Does the staffing company then have a duty to place the employee with another client, or is the employee out of luck? So we're in the interactive process. The client has given it some level of consideration, ranging from none to plenty, but they've ultimately decided that whatever accommodation has been sought is too costly. What is the staffing company's obligation?
So as any other employer, you're still in your obligation as the employer, because you are still the employer, is to work with that individual for a reasonable accommodation, whether it's at that client or whether it's at another client. And as soon as those issues start getting raised, I would hypothetically advise that your HR department start getting in contact with the field to see if there are other job placements that are available, so that you have something in your back pocket in case that client can't meet their needs, and that you're prepared. There's usually always another option that we can work with to try to figure out what a solution is. And we do primarily, or my background is primarily in light industrial staffing. We do also do some tech and professional now in my new role as well. And those light industrial jobs are sometimes hard to find somebody a reasonable accommodation that meets their needs. But if you've gone through everything in your database and you don't have anything, then unfortunately that's the answer, is that we don't have anything for you right now. But in most staffing companies, they still remain your employee for a period of time thereafter. And so it's just making sure that the branch is working toward trying to find that person something whenever there's something that would fit.
How hard is it to lean on the client in that situation, where the client comes back and says, look, we have nothing. This person can't lift 50 pounds. We got nothing. And how much really can you push back on the client and say, come on, you got to have something?
Well, and that's the art, right? Like that's the art of balancing that client relationship versus your employees. And again, I go back to, you have to listen to what your client's saying to you. If your client is saying, we broke them and we don't want them now, then you need to be aware of that as to whether or not that's an environment that you want to put your people in moving forward either. I tend to take people at face value. And if you're willing to say that to me, then we're going to have a deeper conversation at the corporate level as to whether or not that's a relationship that is truly profitable for the organization and for the people that we're sending there, or is it too risky?
I'm hoping, just based on the complexion of the audience, and I know where folks came from, I don't think we have too many folks that are just like, they're broken. You never know. You never know. Folks, if you do have questions, whether it has to do with mental health in the workplace or any of the staffing issues, or if there's just something HR compliance related on your mind, you've got two employment lawyers. We're happy to do what we can to answer those hypothetical questions without providing actual legal advice. Here's a question. Abigail, you mentioned earlier about contracted employees who remain temps for a year, 2 years. Is that ever a problem?
In what way is that a problem? So they're still our employees. And I mean, it's a relationship. We had some employees in my prior organization where they literally had been the staffing company's employees for over 20 years at the same temporary assignment for the client, because that's how the client chose to run their organization, that we dealt with the rest of it. So, it's just, again, good communication with your client, good communication with your employees, which a lot of times that's where a breakdown happens in a staffing relationship, is that because you have Frank and Frank goes to work every day, people forget that he's yours. So you as the staffing company have an obligation to reach out to Frank and remind him that he's yours and not the client's.
Here's a question. Rachel asks, with the increase in diversity and inclusion initiatives, many private agencies are including questions on sexual orientation and gender identity. What concerns, if any, would an HR office have with using these new disclosure questions? I don't know if this is necessarily specific to staffing, but happy to turn it to you, Abigail. You had a thought on that?
Well, I think in all of those questionnaires, there's always the option to decline to respond. And so it's, again, I believe strongly in the communication and the presentation and the why. If you can explain to people why you're asking those questions, then that goes a long way to getting the responses that you're aiming for. And honestly, I'll say that about clients too. A lot of times when we get weird questions from clients, the first thing I tell the field to do is say, why? Why are you asking me that? Why are you asking me for only women in that position? Oh, because their fingers are more nimble and they can put the nut on the bolt. Okay, well, now I understand what your need is. So we can do a tactile test in the office to find the fastest people, because that's really what you're asking me to do. And so in those situations, and diversity inclusion is tricky, right? Because you still have to balance your EEOC obligations to not consider protected statuses when making hiring determinations, but yet you also want to be inclusive and representative. So it's a hard balance. One of the biggest recommendations I make is opening up where you're actually posting jobs and from where you're actually recruiting, because word of mouth is going to continue to get you the same people that you have. So making an active effort to find the Hispanic organization in your city that is also bricklayers, or to find, the Young Black Lawyers Association at various different schools, to make sure that you're hitting a very diverse set of potential candidates. And then also to make sure that you are double blinding your onboarding and your hiring process. So maybe you're taking names and colleges off of resumes before you send them to a hiring committee, so that people are actually looking at the same information on the resumes rather than getting those inherent biases up and in the way.
Good. I got nothing to add to that. Folks, we are talking about staffing. We're talking about ADA, FMLA. If folks have questions, we're getting into that Q&A section right now. Pretty much gotten through all our pre-scripted questions, the questions that were submitted in advance. So if you have additional questions, please ask. Otherwise, I'm just going to come up with some, and two lawyers can definitely pratter on for 14 minutes if we need to. But please feel free to ask us any questions that you have. To the extent we haven't answered this before, there was a kind of a general question I got in advance. of this Zoom. And the question was, how can a staffing company ensure that the law protects the temps placed with clients? So we talked a little bit about FLSA. We talked a little bit about FMLA and I-9 compliance, but are there other kind of general steps that the staffing agency can take to protect its temps?
Sure. And again, I know it sounds very basic, but having now been in this industry for a number of years, you do kind of lose track of who's whose. So the first thing that I would recommend is making sure that you are communicating with your temporary workers on a regular basis, whether that's having pre-recorded messages going out via text after their first day, first week, after 3 months, just saying, hey, how are you? Because what can happen in a temporary staffing relationship is that those people can start to feel lost. And so they don't know what the reporting procedure is. Even if something is happening to them, they're not the clients, so they know they're not supposed to go there, but they never actually go to your office because you gave them a job and they go to the other person's office all the time. And so sending out that contact information, reminding them that, are things going well? If things aren't going well, let us know. That's the beauty of temporary work, is that we can find you a better position. And of course, we want to make sure that you are safe, that you are not being harassed or discriminated against, that you are not being asked to do a job that we didn't send you out there to do, which is a big one, because particularly if people have been on an assignment for a long time and they're not supposed to work on elevated platforms, they're not supposed to work in confined spaces, and all of a sudden the supervisor's like, Joe, we trust you, climb in there. Well, Joe needs to know that he's empowered to call you and say, no, I don't have to climb in there, and I'm not gonna. So it's just making sure that you have those relationships with your employees and they know whose employee they are.
Roy asks, he'd love to hear about pitfalls with using a PO. Or someone asked me before this Zoom about, what if we set up our own, a separate entity to basically staff our company? So we're ABC company. What if we set up DEF, and then DEF will provide the employees to ABC? So different variants on the traditional staffing arrangement. So let's address PEOs first, and we can maybe get a little wonkier from there.
So this is really one where you need to involve your lawyer, because there are a lot of different factors that are going to come into play with that. And there are a reason that there are businesses that are set up to do that. And that's going to be my short answer on it. Can you do it? Sure. But I would highly involve your counsel in a very specific nature before you went down that path, because there are other complexities that we've even talked about today as far as maintaining those differentiations between who is the employer. And I think it's going to get a lot cloudier if it's the same organization feeding back into themselves.
I'm gonna cheat a little bit on Roy's question, because I personally don't do a ton of PEO work. I have a colleague who does. So folks, in the chat window, if you want to see a future Zoom Employer Handbook Office Hours focused on using PEOs, let me know and I'll bring him in. But I'll say this about PEOs, and this is something that gets back to what Abigail was saying earlier with staffing companies. You want to do your due diligence when going through a PEO. There are some really good ones and there are some really crappy ones. So from my vantage point, the general pitfalls of using a PEO to hire out of state and out of country employees, just make sure you're baseline that you're using a reputable PEO and start from there. I'm sorry I can't get too much further into the weeds, but again, if people want to hear more about PEOs, let me know. We'll get more in depth on another Zoom. There was another question, and again, I don't think this is necessarily specific to the staffing context. Paige asked me, what is the easiest way to go through the ADA interactive process when you don't have a good job description on file? So let's level set here. One of the best pieces of evidence, perhaps Exhibit A, when unfortunately you're in litigation on a failure to accommodate claim. Exhibit A is your job description, because you're probably telling the court, hey, this was an undue hardship. Whatever this employee was asking was an undue hardship. Or these are the essential functions of the job. Don't just take our word for it. Like, here it is, right here in the job description. These are our essential functions of the job. But if you don't have that job description, is there a way to still establish that certain job functions are essential? How do you go about doing that? I would go back to one of the themes today that Abigail has been just really pounding over and over again. That's good communication. Talk to your managers, right? Find out what these people do on the daily. I mean, a bunch of us have job descriptions that are outdated and not really worth the paper they're printed on anyway. So talk to managers and find out what these employees are doing. What are the essential functions? And an essential function doesn't have to be something that is done all the time. I've used this before. If I'm hired to plow snow in Hawaii, it ain't gonna snow that much, but damn it, if it snows, I better be there. That is an essential job function, okay? So talk to managers, talk to the employees too. Find out, what are the employees really, what do they generally do? What are they focused on doing? What isn't as important? What consumes their day? What doesn't consume their day? What can they get help on? That's how I'd start to go about it. And then, you start to backfill and create what would otherwise be a pretty decent job description, and then create an actual job description. Get that on file. So that's the way I would go about it. Question from Martin. Martin asks, how would you recommend that employers update position descriptions with accurate essential functions? My employer does it annually, usually at annual evaluation time. What do you think of that? Pretty good idea there. Do it annually?
I think that's amazing. I think that's, as you just said, way more often than most organizations do it. And it is, right? It's like handbooks. It's one of those things that everybody knows we should get done. There's always a crisis that precedes it. So yes, if you can keep them updated and that's on an annual basis, I think annual is amazing. But again, it goes back to making sure that they are reflective, as Eric just said, of what's actually happening.
Yeah, I'd go a step further, and maybe this is implied in the question or the comment from Martin, that when you update the job description, let's assume you do it annually, and you show it to the employee, and you work with the employee, and you're getting the employee's feedback, and then you update the job description. Have the employee sign off on that job description, right? Just boom, countersign it right down there at the bottom, and then within that job description, hopefully you are saying, these functions are essential. These are the essential job functions. These are the non-essential job functions, and whatever else goes into a job description. I know that was very lawyer-like. I've seen them before. I know what goes into a job description. You guys know, I'm not going to tell you. But have the employee sign off on it, right? So again, if there's ever an issue down the line, if a failure to accommodate claim ever gets litigated, not only do you have a job description to show the court, or worst case scenario, a fact finder, the jury, but you've got a job description with the employee's signature on it. He or she knew what the essential functions were, right? There's no debate of that. Then the only question is, it was the requested accommodation, does that create an undue hardship or not? So that's a pretty good way to go about it. We've got about 5 minutes left. If folks have questions, throw them up in the chat window. Otherwise, I don't know, Abigail and I can do a song and dance and get out of here a couple minutes. We're not giving out HR credit for this or CLE, so if we leave a minute or two early, I'm not going to complain. I'll throw it out to you, Abigail. Anything else that you wanted to touch upon today that you think the good folks should know about working with staffing companies?
Now, I really just do think that the question why is so underutilized in business relationships. I always harken back to the cutting the ham in half story, which some people may know, some people not. Every year you make the ham for holidays and you dress it and you get it ready and you cut it in half, you put it in the oven, and generation after generation does it until someone finally says, why do we cut the ham in half? And it turns out that the grandmother's oven was too small when she first started making the ham. So a lot of times in business, a lot of issues can be addressed if people will just slow their roll and say, why are we asking for this? why is the client asking for our employee's social security number and date of birth and home address and home phone number, which as a staffing company, that's our bread and butter. Like that's the information you want to keep close to the vest. Oh, well, they need it for their time clock. Well, can we just put in their employee ID number? And can we just put in a universal date of birth? Or can we just put in our address so that they're well designated as our employees? There's usually a workaround that's easy to achieve with the client if everybody will just kind of understand what the bigger picture is rather than just checking off boxes. So again, it's just a lot of communication and making sure that everybody's on the same page.
Question about determining what job functions are essential. Ken asks, do you have any recommended resources on identifying which functions are truly essential, other than the snowplow driver in Hawaii? Well, I'll take it from the. I'm going to take it from another angle, and then I'll come back and answer your question. In terms of how to accommodate employees, given a set of essential job functions, other than going to your lawyer, I would recommend going to Ask Jan. Job Accommodation Network, awesome. EEOC's got some good resources, but AskJan.org is phenomenal. We've been talking a lot about mental health today. They have wonderful resources on by topic, by anxiety disorder and depression and all sorts of things like that. I think you can go there and maybe even save yourself a call to the lawyer, because you'll find some wonderful ideas that you weren't thinking about in terms of how to accommodate employees with disabilities. In terms of resources for identifying which functions are truly essential, again, it's fairly fact specific, it's job specific. So some of it's going to be trial and error. You know, you think on day one that this new position you created that tasks 1, 2, and 3 are essential, but 4, 5, and 6 are not, but you learn throughout the year that that's just not the case. So there is certainly some trial and error involved, but again, it comes down to observing in communications and ultimately memorializing what is essential in some document, presumably a job description. It could be in a collective bargaining agreement. I suppose it could be in, I guess, a handbook, but usually not. But it's going to vary. I wish I could give you the silver bullet answer, but I think it's mostly built off of communication and some trial and error there too. We are rounding up to 1 o'clock. See how I did that? So, folks, if I think there was one question that came in at the buzzer. Should we do it? Yeah, sure. Why not? We'll do one more question. Paula asks, we are creating a new staffing agency within our organization to staff one of our companies with the prospect of adding them all. We have additional questions specifically about benefits. Can we have Abigail's contact information? Oh, it'd be a perfect time to do the plugs. Do you want to give out your contact information?
Sure, always happy to make new friends.
So why don't we do this? I'm going to thank you for the questions. Thank you everyone for attending. How can folks, Abigail, do you mind?
Yeah, I don't mind.
How they can get in touch with you?
They can get in touch with me at my email, which is lengthy, so y'all be ready.
I'm going to type it as you.
It's abigail.morrow@staffmarkgroup.com.
If I spelled it right. There we go.
You did good. Look at that.
There we go. So I want to thank Abigail Morrow so much. As you can tell, I was giving all the tough questions to her because I knew the answers, but I just wanted to make sure that Abigail knew them too on staffing. But Abigail's a wonderful resource on staffing, and thank you so much. And we didn't do it justice today. We just scratched the surface a little bit on mental health in the workplace, but I can all but guarantee that as the year goes on, we're going to see more input from the EEOC on this issue. We might see more input from the Department of Labor. Heck, I guess potentially we could see it, well, OSHA, part of the Department of Labor, we could see it there as well. So keep your eyes out for that. I'll keep you updated certainly on the blog. And everyone, thank you so much for coming out. Thank you for attending. Stay safe. Have a great weekend. And yes, we're recording this. I'll post a link to the recording on Monday. And have a great weekend, everyone. Aye.